Now, Ralston reports.
Welcome back across Nevada to Ralston Reports. It's been 12 years since Metro Police and Henderson Charles Barnard were there on the same night at his house. He was cuffed, pepper sprayed, and roughed up when he opened the door to Metro Police officers looking for Barnard's brother. Barnard, who says he's endured 9 surgeries since then, eventually sued. In 2007, a federal judge named, guess what, Brian Sandoval, granted the police department's motion for summary judgment, dismissed the case. An appeal and trial followed. And now, this month, the Ninth Circuit is affirming the verdict in favor of Barnard. He joins us along with his attorney, Paola Armeni. Thanks for coming on the program. I really appreciate it. Congratulations. It looks like you're finally going to get some money after all these years. I want people to know and distill this as quickly as possible. What happened that night?
3 officers came to my residence, said that they were Las Vegas Metro and that I was surrounded by 20 SWAT officers, and if I didn't open the door in 30 seconds, they were going to kick the door down. And I came out. They asked me my name, you know, a bunch of different questions.
They were looking for your brother?
They were looking for my brother, David, yes.
Does your brother David look like you? Because is he close in age to you?
Yeah, he's a year older than I am, but you wouldn't, if he was sitting here beside me, you wouldn't even know we were brothers.
And so then what happened next?
They told me to turn around and put my hands on the wall, and Officer Theobald went to handcuff me, and when he cuffed me, he tripped over. There was a little flower pot sitting on a TV stand, and he fell and pulled me down on him, and Officer Romanovich then fell on us, and then Officer Gary Clark then grabbed me in a chokehold and pulled me up and away, and when he did, Officer Theobald still had a hold of the handcuffs, and it collapsed 5 vertebrae in my cervical spine. And
you've had 9 surgeries since then?
Yes, and I got I'm fused from C3 down to T1, and I've had a spinal cord implant implanted in me, and yeah.
And so this has taken a long time. One thing that frustrates me about this kind of thing is you read how this happened in 2001, lawsuit in 2003, and finally, what, 10 years later, he's finally going to get, what, $1.6 million?
That's right. I mean, it's a very long process. The average person gets worn down in these kind of lawsuits.
Right.
And they have to go the long haul, and to Chuck's benefit, or to credit, actually, I mean, he really, really stuck in this when a lot of people probably would have given up.
Maybe he had a good attorney, too. You didn't want to say that?
Maybe.
Well, but I guess what I'd ask, and let me play devil's advocate here, because he described it exactly how it's described in the suit, and I've read it. It's a chaotic situation. They're looking for his brother, and maybe they're not sure. You know, he doesn't have his driver's license with him, so maybe they think it's his brother, even though his brother doesn't look like him. And then this guy, you know, trips over the flower pot, accidentally pulls him down. It's a mistake. They weren't trying to hurt the guy. It's just a mistake. What about that?
And that was what they said. They said they thought, actually, Metro's position at the time was that Chuck was actually resisting. But when we went to trial, the argument was they never used a chokehold. So, you know, the only thing they admitted to was the use of the pepper spray and that a knee in somewhat of maybe his lower back region. So we were already having conflicting stories right there. And that's why these cases are so important to go to trial, because you really need a jury to look at all the facts and make a decision, hear both sides, and figure out what really happened on the night of the event.
I think you were surprised, maybe a little bit scared when you first went out there, but you never resisted, right? I mean, you allowed them to handcuff you. The chaos ensued after the guy trips over the flower pot, right?
Yes, sir. It did, and he was against the west wall and I'm facing him just like me and you are sitting here, and I'm leaning against him, and I have my left arm trying to keep my weight off that fella, and the other officer is beside me, and he's got a hold of my handcuff on my right wrist, and then Clark grabs me in a chokehold and pulls me up and away while he still had a hold of the handcuff, and like I said, it collapsed 5 vertebrae in my cervical spine.
Does $1.6 million cover everything? Or however much you're going to get out of that, does it cover everything? Forget about, I mean, obviously the trauma, all that stuff, you can't put a price on that, but what about your medical bills?
Yeah, I think that I had insurance, you know, at the time to you know, to help out with the medical bills and stuff.
You think it's a just sum?
I think what the jury originally awarded was a just sum.
That was 2.1, I believe,
yes,
right?
Yes, sir. And what the judge did when he reduced it $500,000 for no reason, I think that was unjust.
When we come back, I do want to ask you about this. There's an interesting legal issue involved in this case that Brian Sandoval was involved in. It's the issue of these officers claiming what's called qualified immunity. Why is that exist? And should the officers have claimed it? Stick around.
Find archive programs by going online to mynews3.com and clicking on Ralston Reports.
Welcome back across Nevada to Ralston Reports. 12 years after he was roughed up by Metro police officers looking for his brother, a Henderson man is getting $1.6 million. It was reduced from $2.1 million. We have him and his lawyer here. We also invited Metro. They're not here. All right. There is this interesting legal issue that I talked about. These officers claimed what is called qualified immunity, which they are allowed to do, assuming they're within certain strictures of their job. The original judge back in this case was Brian Sandoval, who was appointed to the federal bench before he left to run for governor. He wrote in 2007 when he granted Metro's request for summary judgment and dismissed the suit. With respect to the excessive force claim under qualified immunity, even if the officers made a mistake and used excessive force, if the officer's mistake as to what the law requires is reasonable, he is shielded from not only liability, but having to stand trial at all. The court finds as a matter of law that the officer's conduct with respect to the excessive force claim was objectively reasonable. The Ninth Circuit disagreed. Well, here's what they said. We explained that the officers were not entitled to qualified immunity because, quote, construing the evidence in the light most favorable to the plaintiff, at the time of the incident at issue here, a reasonable officer would have known it violated clearly established law to use a chokehold on a non-resisting arrestee who had surrendered, pepper spray him, and apply such knee pressure on his neck and back that it caused the collapse of 5 vertebrae in his cervical spine. Essentially what happened is that they said Sandoval was wrong on the excessive force claim. It went back, he got to trial, and that's where we're led today. This qualified immunity, though, this is what they're trying to stretch, it seems, the Ninth Circuit said, right?
Right. I mean, qualified immunity is what officers use all the time, and sometimes they are entitled to it. Unfortunately, there are plenty of times that they're not entitled to it, but we're stuck with judges granting qualified immunity very quickly and early on in these cases, and then the client having to go up to the Ninth Circuit to sort of seek a remedy to come back and get their case heard before a jury.
But there is Supreme Court case law, is there not?
Absolutely.
And what qualified immunity is and when it can be invoked and when it isn't. Are you saying it's generally abused by the cops and then lower courts generally do what the cops want them to do? Is that what happens?
It's oftentimes what we see. I mean, it's not uncommon for a federal judge. I mean, Judge Sandoval probably incorrectly granted summary judgment. I think that's obviously our belief, and that's why we brought it up to the Ninth Circuit the first time. But what Judge Sandoval did isn't uncommon. You see federal judges, state judges granting qualified immunity all the time at a very early stage. And what particularly happened in Chuck's case is that the wrong standard was used. You read a portion of the Ninth Circuit that you said you take the facts in the most light favorable to the plaintiff, Chuck. That's what Judge Sandoval should have done, and that's not what appears to of what happened.
We're almost out of time. I don't like asking this question ever, but I will tonight. How do you feel after all this time?
Well, I feel pain every day. Yeah, it don't stop.
Do you feel vindicated at least by what's happening in court?
I do. I feel, you know, there's a little more confidence in our system now, and that what the Ninth Circuit did was, I believe, absolutely right.
Well, we don't have much time on the show. Metro, have any cause to go to the Supreme Court on this? Is there any?
I don't think so.
All right. Thanks to both of you for joining us. I really do appreciate it.